Good evening. Happy Wednesday. This right here is my kind of pleading. This pleading was written by Joshua Garrick, and you're going to see why it's my kind of pleading. This is it. This is the whole shebang. So here's all the BS, and here's the meat. That's it. One paragraph, to the point, gets it done. Good on you. No fluff. Defendant's joint motion to extend time to file a response to the First Amendment complaint. Pursuant to Federal Rule of Civil Procedure 6B, all that is just rules on computing extensions of time. The defendants jointly move that the Honorable Court extend the time to file responsive to the plaintiff's First Amendment complaint. As grounds for the motion, plaintiff has indicated that it will file a Second Amendment complaint in this action. See Exhibit A. Well, this is Exhibit A. Let's see what it says. This is from Delete Laws to Joshua Garrick and Brian Wilson. It's bwilsonafl yahoo.com. I don't know who that is. bwilsonafl yahoo.com. I think he meant to do Benjamin Wish, but I don't know who Brian Wilson is. What's Benjamin Wish's email address? His is bwish@toddwill.com. Yeah. So I don't know. Maybe this was part of Chili's legal team. Anyway, re-opposition query. Mr. Wish and Garrick. He didn't send it to Mr. Wish, so that's kind of weird, but okay. Would you be opposed? I add TuTube and YouTube personnel to the copyright lawsuit. Regards, Jose Decastro, sent from my iPhone. Would you be opposed? I add TuTube and YouTube personnel to the copyright lawsuit. This is not saying that he is going to amend his complaint. Again, it's asking if they would be opposed to it if he did. That's like me asking my wife, would you be opposed to me going out shooting on Sunday morning? Not saying I'm going to go, I'm asking you if you would be opposed to me going. There's a difference, but it's in the framing, and the framing is plaintiff has indicated that it will file a Second Amendment complaint. So that's a bit of a framing deal there. I believe that some of the legwork that Wish has done attempting to frame Decastro as someone who's going to try to run the dollar amount up, try to file motion after motion, try to file pleading after pleading, is going to assist Garrick in convincing the court that plaintiff will, in fact, file a Second Amendment complaint. And I think that Chili also shot himself in the foot, because I believe that it was at the status conference, the first status conference, not the emergency one, but the one that was scheduled for the following Monday, where Chili actually showed up. They were talking about filing answers to the original complaint, and Wish at that point said, well, we're trying to figure out if he's going to amend his complaint. He says he's going to amend his complaint, so we would like for him to amend his complaint first. And Chili said, no, we're going to do this procedurally, by the books, this and that and the other thing, so you have to answer, and then I'll amend my complaint. And that, I think, is going to hurt Chili. That shows what he's about. And so I think the court is going to look at this and read this in the most negative light possible for Chili, and believe that Chili is, in fact, going to file a Second Amendment complaint. Pursuant to Local Rule 15.1b, this requires the plaintiff to serve a copy of the motion to amend with the proposed amendment on the new party 14 days prior to filing the motion to amend with the court. Now, I get a lot of hate from people who tell me that, oh, you're just helping Chili. Well, sometimes helping isn't helping. Sometimes, if you help someone fall off a cliff, it's not necessarily helping. Sometimes also helping Chili moves things towards conclusion faster. And one of the things that is going to get this done really quick and really cheap is if Chili manages to successfully bring in YouTube, if he's capable of doing that, if he's capable of convincing the court with his motion that that is a thing that the court should allow him to do. But if he is capable of bringing in YouTube, they're probably going to 12b6, not just on the Section 2030 protections, the safe harbor protections, but they're also probably going to 12b6 on every possible defense they have. And one of those is failure to state a claim. The 12b6, that's the old standby. Chili's second amended complaint first amended complaint is very vulnerable to it. His second amended complaint probably won't be any better, but having them come through, do all the legal research, not that they have to, they probably have these motions in a bank somewhere and they just figure out which one to pull in. They have a program autofill it with the correct case identifiers and party names and everything like that. And then an attorney signs it and a paralegal fills out or does whatever she needs to do to get it filed, and bada boom, bada bing, you're off to the races. So this might save Josh and Kate money if Google comes in, YouTube, Alphabet, what do they call it? The Alphabet company? Whatever it is. I don't know which entity is going to send lawyers, but they're going to send lawyers. And it's not going to be a lawyer. It's probably going to be 2 or 3, along with 1 or 2 paralegals and probably a legal support staff like a secretary. It's going to be 2 or 3 attorneys, and they're going to end it for YouTube, Google, Alphabet company, whatever it's called. That's happening. I mean, Chili's not going to win against them. However remote his chances of winning against Kate and Josh are, against YouTube, Google, Alphabet, it's 0. He has no shot. So giving Chili the roadmap on how to bring them in is basically like giving Chili the roadmap on how to poke a hungry lion. You know, it's just going to get Chili eaten. So are you helping him? Probably not. But also, this is a backhanded way of saying that Chili's too stupid to have figured this out on his own, so Garrick has to supply him with the answer. Accordingly, defendants jointly request the time to file responses to the First Amendment complaint to be 21 days after a Second Amendment complaint is properly filed, or plaintiff gives notice he no longer wishes to file a Second Amendment complaint. So this is a really weird thing to ask for, but they might get it. They really might get it. With all the background, I think they have a coin flip chance of actually getting this. I know other people are saying that it's a lot better chances of getting this than it is, but this is really weird because you don't get to normally not answer a complaint until the plaintiff files a Second Amended complaint if the plaintiff hasn't already filed a motion. Like if Chili had filed a motion already to file a Second Amended complaint, and then the defendants filed this motion asking for an extension basically to respond to the First Amended complaint until the court rules on whether or not the Second Amended complaint can get filed. That makes sense. But this doesn't make sense. Based on an email, this doesn't make sense. With the backstory of Chili's behavior, saying that he was going to wait for them to answer before he filed his First Amendment complaint, then it starts to make sense. With all the background work that Wish has done to lay out that Chili's just trying to drive up costs, then it makes sense. I don't know the court's going to grant it. This is really a coin flip for me. I think this is a coin flip because normally a plaintiff doesn't have to give notice that he no longer wishes to file a Second Amended complaint if he hadn't filed a motion to file a Second Amended complaint. You know what I mean? This is just weird. It's weird and it's odd, but at the same time with the background it makes sense and it is succinct, and I like that. So that's it. That's the whole motion, signed by both attorneys, so that saved the parties money. Having Josh write it also probably saved Kate way a bunch of money, because if Wish had written it, it'd have been at least 10 pages. and then there's your certificate of service. One other thing I want to point out, I'm helping Chili. This is helping Chili. This is Chili's Ironton case. Chili's already missed this order to show cause date for 11/17, and so Lawrence County's terminated. The city of Ironton's been terminated. Jane Doe has been terminated. Major Chapman has been terminated. And all he has left is Robert Fouch, Evan McKnight, Chance Blankenship, Brad Spoljaric, and Pam Wagner. That's all he has left. But you might notice that this order to show cause right here is due today. Today is 11:30. This is 11:30. It's due by midnight. It's due by midnight today. Now, my time is Pacific time. I believe Ohio is Central time, which is 2 hours in advance. So it's around 10:30 when I'm recording this. I will upload it when it's done, which will leave, and then you'd have to watch it. So that'll leave Mark about maybe an hour tops to write up a sufficient order to show, or a sufficient response to the order to show cause as to why this case should not be terminated. Because this is it. Once Pam, Spoljaric, Blankenship, McKnight, and Fouch are out, it's done. So good luck to you, Chili. It looks like all your big talk about suing the city of Ironton and getting rich. I think that's about what, an hour and a half away when I'm doing this. About an hour and a half away from being dust in the wind. So with that said, thank you for watching. Have a wonderful day, and Mark, good luck, buddy.